Welcome, welcome, welcome to everyone for our very important post-election Prop 19 Peace of Mind webinar. This is a really important issue. It's not that often where we have a specific deadline where we can say, hey, if you don't take action by this time, you're going to face significant problems. But we have one of these deadlines. We're going to jump into that in just a moment. As we get started, we'll just let you guys see us. So first, I think just from us to you, happy holidays.
Yeah.
It's a weird period. I know we have a pandemic raging, but I hope everybody is healthy and safe, and that you had time with your families safely. And I think we had a good Thanksgiving holiday, and it's just good to reconnect with everybody here. Mike, anything you want to add before we jump in?
No, that's just it. I mean, we think of the Peace of Mind members, obviously all the clients we take care of, but it's very special. And, when we're struggling with the holidays and, are we seeing everybody we want to see, to add some issues they have to worry about? It's kind of a bummer, but, as we always say, we deal in reality. And reality is that we have a couple more things to think about here that have decades and decades and decades and hundreds of thousands of dollars of implications here.
Yep.
So, we do want to embrace the holidays, be, as upbeat as we can possibly be. And I really think that, dealing with some of these issues, I think it makes us feel better. I mean, that might sound odd, but, if there is something there, we don't want to have our heads in the sand. We want to know what's going on. You want to be a step ahead.
Yep.
And, on some of these issues, last thing I'll say is that we're, as I've said, we're kind of first out of the box as we've looked at Prop 19. We a couple of weeks ago, about a week ago, I had an article in the Los Altos Town Crier about Prop 19. We've done other webinars. Another article is going to be published in a professional journal about this. So we've done our own analysis. We haven't waited for anybody else to tell us what it means. We've waded through this thing to make sense of it for you. So let's get started.
Yeah. So, I think I always like to start with is what drove you to join us here today? Take a moment, just think about that. What's on your mind? What are you worried about? Are you worried about your finances or your family's future, the implications of the election? Do you just feel overwhelmed? And that's a very reasonable thing right now. There's a lot going on. We're going to try to focus almost like a laser on this critical issue of Prop 19. And after we get through this presentation, you're going to understand it better than 99% of the population. We're pretty sure about that. There is so much misinformation out there. We're not necessarily misinformation, but what we've read about this has really hidden the ball. The key issue is one we're gonna cover it, but you will not get this if you look at the Mercury articles or the Chronicle articles. We've actually reached out to the Mercury to try to help them to correct this, and they haven't gotten back to us. So it is what it is, but that makes you here part of the key core group that's going to be way ahead of this. And again, thank you for being valued members of our Peace of Mind community. We really appreciate you guys, and you're part of our extended family. So we really value our connection to you, and we hope you get a lot of value out of this. What is the agenda today? Let's go through some of the key issues. Not too many issues. Again, the implications of the election with a focus on Prop 19, which has potentially devastating property tax implications. And there's a deadline. So we're going to tell you about that deadline, what you need to do before, if you decide to take action. Not everyone will, but we think a lot of you will. We're going to talk about some special needs planning issues that are connected to this. If you have a special needs trust, if you have a child with a disability, extra attention must be paid to this, because this has potentially, again, devastating implications if you want to preserve your house or other property for your child. We're going to talk a little bit about the estate tax post-election, what we need to be aware of. That's not really the focus today, but it does kind of all tie in to protecting family assets. And we're going to talk about, circling back, how to protect your home. That's really the focus of today's talk, what you can do to make sure that especially the family home is there for future generations. Let's talk about our homes.
Yeah. And would you put everything up there? So the point here is to, you get this, that, our homes around here are worth more than we ever imagined. It's kind of the luck of where we happen to live. Millions of dollars for our homes. And the key point for the moment is that the values relentlessly go up. So when we think about this in the context of a Prop 19 and what that means for property taxes in the future, the effect of Prop 19, when we think about estate tax avoidance, which is totally integrated with the property tax issue, we have to be realistic and realize that if you have a $3 million home or a $2 million home right now, in 10 years or so, it's probably going to double. You know, you said, no, that can't happen. I've said that many times, and I've been wrong every time I think it can't go up anymore. So, you know, realistically, we have to think, we have to think in terms of ever expanding values of our homes. So it's kind of a reality check as we proceed here today.
Yeah, and again, if you have questions, use the Q&A function. You can also do the chat function, but ideally keep it all in one. Great mess. Thank you, Don, for the very nice message to us. We are happy to be here as a resource for you. So again, if you have questions, put them in the Q&A function. If you can, we'll also try to get to chat function questions as well. And so yeah, this is about the house. And let's go through some situations where Prop 19 has massive implications. Mike, I'll go through this and we can go through the solution. So let's give you 3 different situations, Tom, Jill, and Amos. All 3 of them, think of them as being in identical situations starting out. They have a nice house, but nothing spectacular in, let's call it the Palo Alto Menlo Park area. $3 million fair market value. If they were to sell their houses, they could get $3 million for them. The assessed value, though, is only $300,000. That's Prop 13. It keeps the assessed value very low. So they bought their houses a long time ago. The assessed value can only go up at 2% a year, even when the market value is going up by 8% per year. So you have this massive gap. Each of them has a $3 million house with a $300,000 assessed value. So their property taxes each year, let's call them $3,000 a year. They're actually a little bit higher than that. $3,000 a year in property taxes, $3 million homes. Tom, let's say that, I'm sorry for Tom, Jill, and Amos, but all 3 of them are going to pass away in 2022. And this is just to make a point. Tom passes away in 2022. He leaves it to his daughter. His daughter from day one's like, I don't want to live here. I'm just going to rent it out. What happens? Property taxes go up from $3,000 a year to $30,000 a year or more. So about a 1,000% increase in property taxes. They go up not 5%, 10%, they go up 10 times to $30,000 a year. Jill, similar situation, leaves the property to her daughter. Her daughter decides to live in the house. So you think, oh, well, she's living in it. I heard Prop 19 protects the house if a kid's going to live in it. Wrong. There's some protection, but property taxes will go up in this case from $3,000 a year to over $20,000 a year, even if Jill's daughter lives in the house she left to her. Amos, on the other hand, identical situation. When he passes away in 2022, his daughter takes ownership. Regardless of whether she rents it out or lives in it, her property taxes stay at $3,000 a year. How is this possible? What's this mystery? What did Amos do that Jill and Tom didn't do? Because we're talking about tens of thousands of dollars per year. That adds up to potentially millions of dollars when you look over decades, if you hope that the family home will stay in the family. So Mike, do you want to talk about?
Okay, so let's look at Tom, Jill, and Amos. We had Prop 13, which is famous or infamous in the minds of some. And then we had Prop 58. Prop 58 is the proposition that said that you could pass along your residence or another $1,000 in assessed value for real property to your kid or kids, and property taxes don't go up. Well, Prop 19 just eliminates that. For Tom, where his daughter is not going to live in the house, full reassessment, no protection whatsoever. Again, she's going to rent it out. Jill is going to live in the place. So there's $1 million worth of assessed value protection. The formula is not simple. We read and reread and reread the actual language of Prop 19 on how this $1 million protection is calculated. It is not clear. Virtually everybody is saying that, so we're waiting for some clarity. Bottom line, there's about $1 million worth of protection, but only $1 million. And again, think about our real property values here. Amos, what's the difference? Obviously, Amos took planning steps. He took care of this before the deadline. Again, February 16, 2021, that's the date when Prop 19 goes into effect. So by every indication, if we take appropriate steps before that date, we can capture for your kid or kids the current level of property taxes. We do have that deadline. So we'll go through in a moment, a little bit later, how that works, what the issues are, and how you should be thinking about it.
Yeah, it's a huge.
So our next topic.
Oh, go ahead.
Yeah, I'll just say that we talk in every webinar, and Mark is going to reiterate, because it's so important, the role of these family protection or dynasty trusts. If you don't have a kid with a disability, this is the trust, as you know, that we so strongly recommend, and you've probably set up. About 85% of our Peace of Mind client members have set up these trusts for their kids, as you should. They play an integral role here, that we don't ignore them, that they're going to be the recipients or the receptacles into which your properties are going to go. And that was the case before Prop 19, and that would actually be the case after Prop 19. Okay, so Mark, let's go through that and just really reiterate to everybody.
And I think everyone here, you've heard us talk about these before, but I think it's always good to get a reminder. Many of you have family protection trusts in place. Now, why would you do this? Again, instead of leaving assets, and this is consistent with any Prop 19 planning we would do, but instead of leaving assets to your kids directly, you leave them to family protection trusts. Why would you do that? Lots in the media about these. They're generically known as dynasty trusts. Our version is family protection trust. By leaving assets to family protection trust instead of to your children directly, 3 major benefits are achieved. 1, if your kids get divorced in the future, assets in the trust are not commingled. They're not lost in a divorce settlement. So what you leave to your kids, your family line, will stay in your side of the family, for your kids, your grandkids, your future great grandkids. If your child is sued, I had a meeting yesterday with some clients who faced a frivolous lawsuit. Assets that your child inherits directly, fair game in a lawsuit. If it's in a family protection trust, you've erected some form of a barrier. It creates another layer of protection against lawsuits. When your children pass away, this is huge. We're going to talk about estate taxes in just a second. Everything you leave your child and the future growth in the trust, there's some limits to this, but largely speaking, virtually everything you leave your kids plus future growth is not part of their taxable estate. So it goes to the grandkids free of estate tax exposure when it goes from your children to the next generation. That alone can save hundreds of thousands or millions of dollars. And we think that estate taxes are probably more likely to get more strict in the future rather than more lenient. Who knows? But it's a good way to future-proof your planning. And as we've always talked about, you don't need to name a third-party trustee. You can to oversee it for your child, especially if they're young. But at a certain point, your child can be his or her own trustee. So that it's kind of the best of both worlds. You get these protections and your child can still be in control of the assets in the trust, largely speaking, without too many strings attached. So really powerful trusts, and we think that they should be part of everybody's plan. They last for over 100 years in California. So it's multi-generational protection. And again, Prop 19 planning, protecting the family home, all of this is consistent with family protection trust. So it's not like this, what we're talking about would replace that. It's consistent with it. So just a reminder, and if there's anybody you know who has these issues, let them know. These trusts exist and there's a lot that can be done.
Yeah, I have to say, remember, as we said in the last slide, the ultimate greater beneficiaries of these trusts are the grandkids, right? Because it's going to protect the assets you leave your kids. And it isn't just for the grandkids, it's for those perfect grandkids. We have a new grandkid. So we're swimming in that wonderful sea right now ourselves. So,
6 weeks old now, Miles, Ethan.
About 5-6 weeks old now. Yeah.
Miles, Ethan, Gilfix West. My younger sister Jamie had a baby just a few weeks ago. So yes, you guys have been, my parents, Mike and Myra, have been at the Gilfix West residence in San Mateo like multiple times per week, bringing meals and feeding Miles and hanging out with him. And I've been
changing diapers.
So yeah, it's all about the kids and the grandkids. And yeah, it's about family. That's what this is all about, protecting what you've worked so hard for your family.
Yeah.
So let's circle back to the election. There were 2 initiatives we were really paying close attention to, Prop 15 and Prop 19. Prop 15 didn't pass, so obviously we're not going to talk about that. It could come back in the future. That would have property tax implications for commercial properties. But Prop 19, ironically, when you take a step back, it tells you a lot about how the election system works. Prop 15 would have largely affected corporations, wouldn't have affected the vast majority of families in California. It really was about changing property taxes for commercial and industrial properties. That didn't pass. Prop 19, which affects the vast majority of families in the Bay Area and nicer parts of California, that did pass. Now, why was that? Well, Prop 15 had an industry that fought it. So there was a lot of money that went against it. Prop 19 had an industry that was for it. The California Realtors Association pushed really hard for this. And I think you'll see why. And this is not a criticism of realtors, but Prop 19 is going to create a lot more home sales over time because of these property tax issues. A lot of families will have no choice but to sell their homes when they go from parent to child. So let's circle back. We've talked about this quite a bit. Let's go through some of the key rules here. And again, it's an alert. There's a February 15th, 2021 deadline for taking the action we're talking about here. And I just want to add, even if we don't want you to wait, but after February 15th, we will eventually develop other solutions to deal with this. But I can say they're going to be more challenging than what we have right now, because once the new law is in place, it is going to get a lot harder to create protections for this. So as Mike said, as of February 16th, 2021, Prop 58, which meant that a primary residence for mom and dad could pass to their children, no matter how the children used it, whether they rented it or lived there, with no property tax reassessment, plus $1 million in additional assessed value property. So you could pass a house, a fourplex, a duplex, and for many of our clients, multiple properties could have gone to their kids and still can with no reassessment in property taxes. That's gone. That is gone now, starting February 15th, 16th, 2021. And again, I think the big misconception here was that if you just read the surface level analysis of this law, you'd say, okay, well, if the house goes to the kids and they rent it out, okay, full reassessment, I get that. But I think a lot of people thought that if a house went from parent to child, and if the child lived there, that there wouldn't be a reassessment. And that's wrong. As we've talked about, only $1 million is protected. And the law could not have been written in a more confusing way. We as attorneys have had to read it like 5 times just to try to make sense of their formulas. And their formula is not even internally consistent, by the way they laid it out, but we're learning it.
Let me insert that the reason you might think that if the house goes to your kid and lives in it, that it's protected, you might think that because an article in the Mercury said that.
Yeah.
I mean, it was wrong. Yeah. But there it was.
Yeah. If your house is worth under $1 million, yeah, that's true. It will not be reassessed. But if you have a house in the Bay Area, we had a question, my house is not in the Bay Area, not worth as much, then it's not quite as clear a situation. But we can talk about the trade-offs and what you'd want to think about. But, in the Bay Area, in Palo Alto, along the peninsula, or rental properties, that's a big issue. Rental properties get 0 protections no matter what. So if you have a rental property, you have to be thinking about this. If your house has gone up by more than $1 million since you bought it, you got to be thinking about this. And tens of thousands per year are at stake. When you add that up over the years, again, we're talking about hundreds and hundreds of thousands of dollars for just one house. If you want to keep that in your family, that's what's at stake here. Again, we're hammering this. This is a Prop 19 webinar. Mike, do you want to go through this?
Yeah, we're purposefully being repetitive. Okay, we want to talk about this from a number of different angles and just make it clear. And there'll be some nuances every time we touch on these points. Okay, before the deadline, if the residence goes to the kids, property taxes are not going to go up. If other property goes to the kids, again, with this $1 million worth of assessed value limitation, you could have a $4 million fourplex, but it could be assessed at $800,000, which would allow you to pass it along without a property tax increase. After February 15, maybe protections, as we said, for the house, only if the child resides in it. And by the way, they also have to file the homeowner's exemption immediately. If they don't, it appears from our reading of Prop 19 that if they wait 6 months, they're going to lose 6 months worth of property tax protection. It'll go up for 6 months and then it'll come back down, but they'll lose all that money. Everything else is reassessed. Everything else is reassessed. And so many of you have a second property or perhaps, a small fourplex kind of thing. So it's for you.
And another issue that we've just kind of realized is even if you think your kids are going to sell the house after you pass away, if you don't take steps now, it takes time to sell a house. Even when it goes from parent to child, it takes at least 6 months, often over a year, as you get the house ready, you hire the realtors, you remodel, you wait. Just in that 1 year, the property tax increase could be $50,000, $40,000, depending on the value of the house. So even if you think your kids are likely to sell a house pretty soon after you're gone, it still may make sense to take steps to protect that. That could be $30,000, $40,000, $50,000 in extra property taxes that you can avoid if you take steps before.
That's a
So,
really good point. I didn't think about that.
yeah,
I
this
really
came up in-
didn't.
some of our great clients asked that question.
Yeah, we're
And so,
evolving.
yeah, so I want to thank clients. And again, if you have questions, feel free to enter them in the Q&A function. We're going to get to some at the end as well, for sure. So again, February 15th deadline, because February 16th is when this new law comes into play. So let's go back. Let's just explore this a little bit more. And Mike, you can, I'll go through this right here. So
Okay.
let's give an example with, as we said, if you have a fourplex or rental property. So let's go back, Tom, Jill, and Amos. And again, the power of planning. Tom and Jill didn't take any steps before February 16th, 2021. Sorry, and as a result, even if their children live in the house, still a big property tax increase. And if their kids don't live in the house, massive property tax increase. Amos took steps beforehand, was able to keep low property taxes for his daughter indefinitely. Rental properties, it's very, very clear. If it's not the primary residence, absolute 100% full reassessment for any transfer after parent-child transfer after February 15th, 2021, February 16th, 2021. So let's say Bill owns a fourplex. As Mike said, Bill owns a fourplex. Let's say it's in Sunnyvale. It's worth $2 million. He bought it decades ago. So the assessed value is only $200,000. When this goes from Bill to his kids, property taxes go from $2,000 a year to $20,000 a year or more indefinitely. So for rental properties, that can make a property go from somewhat profitable to not even profitable anymore if you have low rents. And right now rents are down significantly. So if you own rental property, critical issues as well. Andre owns a fourplex, same thing. Let's say Bill versus Andre, same thing. Andre owns a fourplex worth $2 million, assessed value of $200,000. Andre took steps before February 16th, 2021. When he passes away, property taxes remain at $2,000 a year indefinitely. So huge numbers here because Andre took steps before February 16th, 2021. And let me just see, we have some good questions coming in. And yeah, so good question. We'll kind of circle back to this very good question from Paula. So what happens if the child lives in the home for some periods of time? Like maybe they move into mom and dad's home right after mom and dad pass away, but then move out and no longer call it their primary residence. The law doesn't say. Mike, what are your thoughts there?
That we've discussed that exact question.
Yep.
It appears from a reading that the homeowner's exemption, if the child moves in, has to be filed within a year. And if you don't, you could lose that. Implicitly, but not explicitly, the filing within the year saying it's my residence, you can only have one residence, you can't have two, you're in, you should be protected. But there's going to be some clarification from the Board of Equalization to interpret some of this. So we can't say for certain. So, but conservatively, you would not expect that. You'd have to continue to make it the resident. We actually think you're going to be okay, but we don't know for sure.
We don't know.
Yeah.
So let's go to just a couple of closing points, and we'll just dump into some questions after that. So
yeah,
what can you do before February 15th? Mike, do you want to jump in?
Okay. There's not one solution.
Yeah.
There's a number of different things that could be done. The best solution for you is going to depend not exclusively on the profile, the information about your home or your other real property. It has to be integrated into thinking about your overall estate, because some of the solutions that are probably going to make sense, that will make sense for most of you, will be questionable if you have a large taxable estate. So like if you're over 10 million grand total, that's a major factor we have to take into consideration as we do the planning. Okay, for most of us, the our tax guy, you all know Francis LaPole, he's our tax guru. He also happens to be a realtor. So that blending of experience and knowledge has been absolutely perfect for him to think this through. And boy, has he spent time working on this and thinking about it. And we've developed a new kind of an irrevocable trust. Now, in this office, we do 10 or 12 different kinds of irrevocable trust. So, we can't go out and get an irrevocable trust. This is fine-tuned to fit this circumstance. And all these trusts are not going to be the same. Again, it's going to depend on a number of factors. So the important thing here is, talk with us. We have more to say about this. We'll talk
Yeah.
with us about this, and see if it fits, and to make sure that we have time to get this kind of work done for you when and if it makes sense. Bottom line here: coordinate with the Family Protection Trust. So, if you might transfer a property into this new irrevocable trust, ultimately it's going to end up in the Family Protection Trust, or maybe the Special Needs Trust. Depends on your circumstance.
And we've seen what some other attorneys have talked about as solutions to this, and we don't think that they're right necessarily. We think that we've developed an excellent solution that we would be able to explore with you, and it's case by case. It might not be right for you. There are trade-offs no matter what you choose to do, but it's something you need to explore if this is something that concerns you. It's just such a challenging issue. And I think related to that, special needs planning. So of course, that's a big part of our practice. Mike and I just published a new version of our special needs trust book. It's available now. It's hot off the presses. Obviously, that's a big part of what we do. We're very proud of our special needs practice. If you have a child on the autism spectrum or a child with disability, if you've created a special needs trust for them, if you haven't, you need to create one. And if there's anyone in your circle, your family who has a child with this situation, let them know that we can help them or that they need to create a special needs trust. Obviously, we're a resource for that. But there's some special issues for families with special needs children in Prop 19, because there is no protection or there's no exemption in the law if a house is going to a child with a disability. So Prop 19 is especially potentially devastating for our many client families who have worked so hard to set up a special needs trust for their son or their daughter who has special needs, and who want to make sure the family home is there for them. We have a lot of families where they'll tell us, look, this is my son's home. It's really important to me that my son gets to stay in this home. Prop 19 has potentially massive implications there, because all of a sudden we're anticipating property taxes staying at a low level. All of a sudden, the expense of staying in the home might be $10,000, $20,000, $30,000 a year higher than anticipated. That's on top of all the other needs your child's going to have. So, Mike, any thoughts you have there?
Yeah, this is our biggest worry. If your kids are okay, doing fine, it's great to protect the property for them. They're going to get along regardless. We have so many client situations where the home, the family home, or maybe a second home, is the only home your special needs child knows. That's where they're comfortable. The family plan, the plan forever has been that your kid is going to live in that house, whether it's your residence or a different property. So, the impact here, again, is that we could have property taxes going up $10,000, $20,000, $30,000, $40,000 a year. We have so many clients who bought their homes decades ago, and now they're worth $4 or $5 million. And they might not be a massive house. It's just location. So what that does, if you think about it, we're adding $400,000 to $1 million. Just do the math. Your kid lives another 30 years, 35 years. And we've got these dramatic increases. So the amount of money that has to be set aside in the special needs trust just to take care of property taxes, it adds another maybe $500,000 that has to be added to that trust. So number one, we have to think through how much is enough to, we're going to keep government benefits, right, for the special needs trust. But there's so many other costs that have to be paid for, maybe a special aid, somebody to live with her, whatever it may be. And you may have budgeted for that. You may have other kids where you want to leave maybe you want it to go equally. This might not let you leave the entire estate in equal shares to all of the kids. Mm-hmm. So it's a matter of mathematics and taking a fresh look at the special needs planning that you're doing. So again, if you have this issue, it isn't that you have to take these steps, but you have to think it through, understand the options, and just see if any adjustments are needed. And I'll give you the last quickest example. A dear client who lives in Menlo Park, through no great planning of their own, their home has grown to be worth about $4.5 million. And it's not a huge place. It is classic. It's the only home their child who has some serious mental issues has known. The entire plan has always been that child is going to continue living in that house. To move would be psychologically devastating. So the entire plan is focused on this. Now, the problem they have is that while that's a very valuable home, they don't have a lot of cash. They don't have a lot of other money, and they have another kid. And they were going to leave it very unbalanced. The home for that kid, a little bit of money, and the rest for their kid who's not special needs. That plan is shattered by Prop 19. It is shattered by Prop 19. And we're going to see that with so many of you and so many of our clients out there in the community. So, we ask you to think about it and, talk with your friends who have special needs issues. Please, let's spread the word so they can take steps.
Yep. And that's really the focus of our talk was Prop 19. We do want to spend just a minute on the federal elections. We get a lot of questions about that and what might happen now. We have a new president. Congress remained in the Democratic Party's hands. The Senate, we still actually don't know. You can't make this stuff up. We won't know until January because we have 2 runoff elections in Georgia, and who knows what will happen. And we saw that polls were directionally right, but still pretty off in the presidential election. State level, some states they were good, some states they weren't. So I think I am not even going to pretend that I have any idea what's going to happen in Georgia, but we don't know who's going to control the Senate. But I do think, let's say it's unlikely that Democrats will win both of those seats in Georgia. And so let's go through what the election means, what it doesn't mean. Will tax laws change? Will trust law, family protection trust still be okay? So I think the first answer is we don't think there are going to be major changes in the next year unless Democrats win both seats in Georgia, which I think is unlikely. If they do, it's possible we could see a change to estate tax laws in the next year or 2 before the next election. If Democrats don't win both, they just win one, then gridlock. We have Republicans in charge of the Senate, Democrats in charge of the Congress and the presidency. So will tax laws change? Frankly, we won't really know until after the end of the year, which is a little frustrating because by then it may be a little bit too late. So if you're really conservative and you're really worried about estate taxes, you may want to take action before the end of this year because they could absolutely make changes to law that would apply starting January 1st, 2021. We don't think there are going to be major changes. I think the odds are that there will not be major changes, and we don't see any threats to family protection trusts and protective trusts that we might create that are kind of independent of estate tax numbers. These are trusts that are just there to protect assets. We don't see major issues for those. But we do have to keep an eye on things because we're all worried about the death tax, or what is really known as the estate tax. I just think this image is kind of funny. We discuss this all the time. It's like, is the Grim Reaper getting the tax bill? If that's true, that's really good because he's getting your tax bill. Maybe he's going to pay it for you, or maybe he's delivering it, but then why are there cobwebs in the mailbox? Anyway, we're all worried about the estate tax because it's punishing. It's 40% of every dollar that's exposed. So let's just review the rules about the estate tax. Again, this isn't the focus. It's just kind of a refresher, and then we'll circle back to Prop 19. We're getting a lot of good questions about Prop 19. We will get to your questions in just a second. The current estate tax level of protection is $11.58 million per person. That's how much can go via gifts during your life or bequests after you pass away, free of any estate tax exposure. Any dollar over that is taxed at a 40% rate. So, but for a couple, if you take all the right steps, administer the estate properly and all that, you can pass over 23 million under current law. And it's currently set to go up to 11.7 million next year. Mike, is that right? I think that's
January 1, 11.7.
Yeah, and there's no, and importantly, the receipt of an inheritance, when your kids receive an inheritance, that's not taxable. So it's really powerful to receive an inheritance. There's no income tax on that. And California doesn't, some states have state level estate taxes. California does not yet. And we say yet because California is very good at finding new ways to tax you. There have been bills introduced into the assembly and the committees to talk about a state level estate tax, but it hasn't gone anywhere recently. But we live in California. Keep an eye out for that, but we don't see anything in the near term horizon about that. So you might be thinking, well, 11.58 million per person, that's a huge number. That's over 23 million a couple. I don't really have to worry about that. Well, I think one, Mike, you can just talk, your state's bigger than you think. First of all, the value of your home's going up. Anything you'd add there?
Yeah. Okay. We just want to make the point that when we sit down with somebody and ask, what's the size of your estate? If you're not an engineer who just keeps that thing up, that spreadsheet up to date, you'll come in about 20% too low. So if somebody says to me, the estate is X, I'm always saying, well, it's really about 20% more than that. I'll tell you, invariably, that's right. Now, with you, we maintain your Schedule A and your trust, so you're more on top of this than most people. But a reminder, If you own a life insurance policy or you're paying the premiums, the death benefit is part of your taxable estate. IRAs, 401ks, the gross value is part of your taxable estate. If you own property in another state or in another country, that's part of your taxable estate. Could you inherit something? That's going to be part of your taxable estate. Again, we want to take the long view. And again, the growth and the value of your assets. It's bigger than you think, and you got to worry about that. 40% is a heck of a tax.
Yeah, and you still might be thinking that, well, that's all great, Mark and Mike, but I'm still not close to 23 million or 11 million, which is true for 99% of the population. So if you do have an estate of that size, you got to be thinking about this 100%. This will be an issue for you. But even if your state's not that big, we got to be looking to 2026 or sooner, because winter is coming. You Game of Thrones fans, you don't need to be a Game of Thrones fan to know that winter is coming is not a good thing when it comes to taxes. So the current law, if nothing happens in the Congress or the Senate, if they don't pass any new laws, the current law will sunset in 2026, January 1st, 2026. At that time, the exemption will be cut in half from currently 11.58 million. It'll probably be around 6 million per person. And keep in mind, in 6 years, the value of your home is probably going to be worth substantially more. If you have rental properties, substantially more. If you have investments, probably going to be worth substantially more. So the size of your estate is going up while the exemption is about to drop off a cliff in a few years if nothing happens. So this is if Congress doesn't do anything, if Republicans and Democrats are at loggerheads, and it could change before then. Again, we got to keep an eye on the Georgia runoff. We got to keep an eye on what happens in 2 years and 4 years, all of that. So a lot could change, and I think it's just something we need to be aware of. And our firm is a resource to you. There's all sorts of tools. I don't think we should spend too much time on this, Mike, but
definitely not.
You can go through some of, yeah. And Mike just published his new version, a new version of his book, Beat Estate Tax Forever. There's a new edition that's about to be published that goes through all of the different tools we have, separate from Prop 19. And Prop 19 issues do intersect with this. This is why we can't give you just easy, clear answers. You have to think about all these issues together, because you don't want to save a little bit in property taxes, but then face way more in estate tax exposure, or you want to weigh all these decisions. There's so many tools we have available to reduce estate tax exposure if this is an issue for you. And you add them?
No, that's fine. You know, you have to think in terms of there being, for if you're a married couple, 12 million come 2026. Will your estate be more than that? If you're a single person, if the estate is more than 5 million currently, you have to be worried about these things. The point is, we have many, many, many tools available to us to reduce or eliminate your estate tax exposure. But you know that. You're in the Peace of Mind program. You've heard us many times. And as Mark said, the third edition of my book, Beat Estate Tax Forever, many of you have the second edition. It is done. We just had to change the cover a little bit. So it'll be published in our hands in maybe 2 or 3 weeks. So be in touch with us if you'd like to get a copy.
Yeah, it just gets hitting this over and over again. Do you need to worry about this if you don't have well over $5 million? Like, yes, you need to be aware of it. Again, it could be hundreds of thousands of dollars at stake. We work so hard through our whole lives to invest well, to buy the right assets, to make the right decisions, to save money here and there. Don't make a couple bad decisions later in life that undo all of your good decisions during your life. I think that's the key thing. So let's circle back to really the focus here.
Let's do that. All right.
15th deadline.
So this is what you should be thinking about and what you should look at and what we will need to know to advise you. Okay. So let's just look at your residence. This applies to another property as well, but let's think about the residence just for this discussion. Okay, what's the market value? Why is that important if we're thinking about a transfer now? You've heard us use a lot of lingo in the past, and I'm going to use a little bit of lingo, legalese here, some tax points. I'm going to assume some basic knowledge on your part as I go through this, and we think you'll be comfortable with it. And again, the point is that it's a multi-element equation to figure out what's the best approach for you. We have to think not just about property taxes. We have to think about capital gains taxes if the property might be sold later on. We have to think about estate tax exposure. So let's go through this and we'll that'll make a little more sense here. Okay.
Yeah.
So,
okay, go ahead.
Market value, what's it worth? Let's say 4 million, 3 million, say 3 million. Okay. Cost basis, remember, cost basis is the price you paid for your home. If you added on, if you had a $300,000 improvement, that adds to the cost basis. But for most of us, the cost basis is very low relative to market value. Current property taxes. What's the assessed value currently? That has nothing to do with cost basis. It has nothing to do with market value. It's the tax assessed value. You get that statement every year. And that's what generates the property taxes that you pay every year. Then what's your goal? Are you committed to the idea of keeping the property in the family? Is the kid going to live in it or not? If that's the case, that certainly takes us down the path of thinking about steps to protect the current level of property taxes. If you might sell it, if you're convinced you're going to sell it right away, then the property tax issue is there because of that really great point that Mark made earlier, that even 1 year of increased property taxes, there's 30 grand, maybe it's 40 grand. But if it's going to be sold right away, right after someone passes away, because of that thing called the stepped up basis, then you don't have this property tax issue. So here's a couple of comments about how these things fit together real quickly. If you just give your home to your kids right now, to these dynasty trusts or the special needs trust, they'll take your property tax level, and that's fine. But if you give it to them, they take your cost basis. So if there is going to be a sale someday, and that could happen, they're going to pay an enormous capital gains tax. So one of the approaches that we take, we structure the trust so that even though we're going to transfer it effectively to capture the level of of property tax protection, we want to get a stepped up basis. And and that's one of the benefits of the structured approach, so that if there is a decision to sell later on, property taxes can be eliminated. If that's done, that property is part of your taxable estate. So we have to do the math to make sure that we don't save 40,000 here and expose you to 300,000 over here. Yeah. So everybody's different. We're thinking this through very, very carefully, on your behalf.
Yeah, and if you think you might sell your house in the future yourself, then probably doesn't make sense to take these steps. But if you want to hold on to it. So I think the key thing here is before February 15th, we've thrown so much at you, and we're going to get to questions in a second. And I don't want to get too bogged down in details because every situation really is different. Truly, some of the solutions we've seen out there from some other attorneys, we don't think are really right for a lot of families. We think we have a lot of great tools in our arsenal to help you. And again, the deadline is coming up. And if you take steps, you can save the family home for multiple generations. And all this is consistent with leaving it to the Family Protection Trust. And we're calling generically one of our key solutions the Property Protection Trust. And just imagine the stakes here and what we can achieve if we work together on this. These are very high stakes issues. It's about saving the family home and making sure your kids have an option to be there. So what can you do now to protect the house and to at least understand if you should take action? Because not everybody on this webinar, not every one of our clients has chosen to take action, even the ones we've already met with about this. It's not right for everybody, but this is an opportunity. And while this is top of mind, we have this deadline. Take action. You are the smart money. Sometimes you hear, what is the smart money doing? Is the smart money, you see it in the venture capital world, you see it the sharps when you're betting on sports. You are the smart money when it comes to protecting your home. Communicate with your family and take some action. Taking action might just be learn about these issues, understand it so you can make an informed decision not to take further steps. That's fine. Set your appointment right away with us. You are Peace of Mind members. We do have some times available in December and January. We really need to meet with you in the next few weeks. And we can review if a property protection trust or a different type of trust or if any steps are needed or wise for you. You need to understand these steps. And in an ongoing basis, this is all about coordinated planning. We don't, as we tell you all the time, we don't see our relationship with you as a one-off thing. We want to help you over time. So this is one of several issues you're going to face over time. So just stay up to date on these things. Keep an eye on that Georgia runoff election. Set your meeting with us. Use your Palm Hour if you haven't yet. Even if you've used your Palm Hour, your annual Peace of Mind hour, it's still worth setting a meeting. The issues are just too high stakes. Our attorney team is ready. So my calendar, Mike's calendar we're pretty booked up, frankly, through the end of the year. We have some availability in January, and our other attorneys, Nick Klingenberg, Renee Conrad, are excellent. We all work as a team. And we've discussed these issues as a team. So whether we're with me or Nick or Renee or Mike, we're going to go through these issues with you step by step. So we're doing our very best to accommodate all of our clients who set meetings very soon. We're going to prioritize our existing clients as best we can. And we really got to take action pretty soon, because, if you come to us on February 10th, you're like, hey, what do we do? That's probably going to be too late. We're going to have too much stuff to do before then. There's a lot of steps we have to take with the county. So set your meeting. You know how to call us. You can email Ashley on our team, ashley@gilfix.com. Take some action though. Think about if these issues apply to you, and it's just a high level. If your house is appreciated more than $1 million since you bought it, it's probably a very good idea for you to at least explore this. If your house is worth under $1 million and that's all you have, maybe not an issue. Or if you just recently bought your house and your property taxes are very high, maybe not an issue. But get educated. Get educated. We are here for you. So use your peace of mind hour, set that meeting, and we're here to serve you. So on that note, let's go to the many questions that we have, some really good ones. So
hey, the first thing I want to, sorry, Mark, somebody sent in a congratulatory note on the birth of the grandchild. So thank you for that. We appreciate it.
Yes.
Go on.
And I'm an uncle, so not as cool as, grandparent, but it's very cool to be an uncle. Great question from Bernadine. What happens, so this going back to Prop 19, what happens if there's more than one child, multiple children inherit a property, and one claims it as an exemption, as their primary residence? What happens then under Prop 19? That gets complicated. Mike, what are your...
Yeah, okay. So if that one child becomes the exclusive owner of that property and makes it the residence, then we have that $1 million worth of protection. If 3 of them own it or 2 of them own it and one child claims it, we don't know. It doesn't say. There's some logic from some parallel areas of the law where if one says it's a residence, that's enough. But the language of Prop 19 doesn't really doesn't clarify that. It doesn't require that the child be the sole owner, just that it's their residence. So there's some ambiguity there.
Lots, yeah. And this is also, not to get into not fun issues, but when someone passes away, our firm does provide trust administration. These are issues when your trust is being administered that it's so critical to have an expert helping you through it. We have some clients, or we've had people call us and say, well, what's the additional value? The trust just said where it's going to go. The house goes here. Why would I hire you guys? Why don't we just do it ourselves? Or what? This is why you hire us, because there are a lot of steps we can take during the administration of a trust to deal with some of these issues that Bernadine very intelligently raised. We'd have to look at what the law says. There are so many steps we can take during the administration of a trust to protect property taxes, regardless of Prop 19, but especially in light of Prop 19. So these are complicated issues. We don't have good guidance. Good question. Do you want to talk about fees for this solution? Or I think it's so case by case. Or Mike, do you want to address what our presumptive fee for the property protection trust, and how we're kind of looking at this?
Francis Lepole is going to be, while all of us are going to participate in the drafting, every single one of these trusts is going to go through Francis's hands. There are, earlier I went through the many tax issues that we have to think about. So he's the one who decides how to deal with, all these really fine tuning tax points. And he's going to be setting, frankly, we haven't resolved exactly what the fee is going to be. We're going to have a presumptive fee. We've spent an enormous amount of time researching, thinking about this. So, it's not going to be a minuscule fee, but relative to the value, it'll more than reasonable. That much I guarantee you. I want to dodge you, but we really haven't set that yet.
Yeah, incredible return on investment. It will deliver many times its value once we develop that. Good question about if mom passes away and it's sold later, and there are tenants in the home when the house is sold, if the house is rented, do we have to pay the increase in property taxes? Yes. So once someone passes away where the house is rented, especially if it's rented, because then clearly you can't claim it as your primary residence. So the law doesn't care who's living there. The law just cares if it's not someone's primary residence. Even if it is, there will be an increase in property taxes if it's in this area and the value's gone up significantly over time. So doesn't matter if it's rented or if it's empty, property taxes go up really the day that someone passes away. You won't get that in the first bill, but they will get you later. They will send you that adjusted assessment and you will eventually have to pay that increase in taxes. So again, as we talked about, even if your kids are going to sell the house soon after mom and dad pass away, if that takes 6 months or a year, that alone could be $40,000-$50,000 in additional property taxes if you don't take steps ahead of time. So good question from Dawn. If we transfer a home now for Prop 19 benefits, how do we retain control? And what if we want to live in it? What if we want to sell it? Great question. And that goes to why this is a case-by-case situation. We need to talk to you about what your issues are. The solutions we have actually still should protect you to get to live in the house, but you're giving up some control to get these benefits. You can't get something for nothing. There are always trade-offs. We think they're great trade-offs in many cases. But if you think you might sell the home and move somewhere else, the value is less in doing this, certainly. But these are all issues we have to explore. We can create structures where you absolutely would have the right to live in the house and enjoy the house long into the future, even if you give up control. And that also relates, we had a good question, Mike. Oh, anything you want to add there, Mike?
Yeah. I just want to go to the bottom line. Yes, if your residence goes into the trust that we envision using for most of us, your right to live in the house will be protected. You will be able to stay in the house.
Yeah. And now I'm going to see, we had some questions in the chat function as well. So actually we had a question for someone who their parents already transferred assets to an irrevocable, we did different irrevocable trusts for Medi-Cal planning in the past. The question is, do we need to worry about Prop 19? And I'm not sure that we have an answer yet about that. We think that trust could provide some protections, but we don't know for sure because we are designing a new trust differently.
So I'll comment on that. Okay, so for so many of our clients, they have to deal with the cost of long-term care. 70% of us over the age of 65, that's me, 70% of us are going to need some form of long-term care, and nursing home care, 10, 12 grand a month. So rather than have your estate absolutely wiped out and then going to the Medi-Cal program, there's steps we take to protect the residents, qualify for Medi-Cal, et cetera. There's a trust into which the home can be transferred to protect it, to get tax benefits, all kinds of things. So yeah, I think that's going to be effective. It's conceptually similar to the trust that we're using here. So I think the short answer is yes.
Probably.
You will keep it. Yeah,
probably
yes.
And even the solution we have now, we have to say, we believe it will be successful. We can make no 100% guarantees because this is a new law and we don't know how counties are going to interpret it. We don't know how the state's going to interpret it. We believe it's extraordinarily likely it'll work, or depending on your situation. We had a good question here. If you create an irrevocable trust for your house, can the grantors, meaning can you, the homeowner, be the trustees of this trust? And so no, you can't, because again, if you're the trustee transfer, the state would just say, well, that's not a transfer. So that would kind of unfortunately defeat the purpose. So again, part of the discussion we would have with you is making sure you feel really good if this is the solution you choose with the trustee choices that you have. We have a question just about, and I'm sorry to hear that one of our clients lost if you lost your home in the CZU fire, so I'm really sorry that you lost it. What happens to our tax basis? That's a different issue. You should be protected. Certainly if you rebuild in that area, you're absolutely protected from an increase in property taxes. And I believe that this hasn't been the focus of our analysis of the law because this is such a narrow situation. If it hits you, it's horrible, but it's such a rare thing, frankly. So I believe you'd be protected if you rebuild, even if you rebuild elsewhere. I think this law added some protections there if you lost a home in a fire. So I think you'll be okay. And certainly the solutions we're talking about are not applicable in that specific situation. So I think we had a request of the new book. So we'll send a new copy of the book to Dawn. So we will get back to you with that. So anyway, on this point, we have to wrap this up. One last question I think is maybe good to address is, we have some very specific questions that are getting into taxes, how taxes would be handled if you created one of these trusts. We'd have to explore that with you in a one-on-one meeting. It so depends and it gets really complicated, but we can give you a pretty clear answer once we know your situation. And one last question. So if you have an A-B trust and one spouse has passed away, and let's say a house is in the exemption trust, that B trust, do these Prop 19 issues still apply? Yes. right? I don't think there's any protection. Just if you have an AB trust and one spouse passed away a long time ago, if that happened, if you have a house in an exemption trust, there are other issues we should talk about, by the way. There's some big capital gains tax issues, but I don't think that would solve any Prop 19 issues. It still would be considered a parent to child transfer. Same rules would apply. So on that note, great questions, everyone. We have such intelligent questions from our clients. I mean, you guys are asking questions that frankly, I think most attorneys wouldn't even know to ask, which is, so we love talking to you guys. So again, I think the key issue here is, if you are uncertain about this, if you want to explore it, we got to set that meeting because the clock is ticking. Again, Nick Klingenberg, Renee Conrad, and our team have some availability. They are awesome. We're all working together. Everything will go through us as a team. Francis LaPole is going to oversee any trust that we create.
Yeah, and let's add that, we really want to have these meetings by Zoom.
Yeah. Oh yeah.
So don't think about coming in. It's more efficient. It works, it's safe. So that's our huge presumption. And we have clients in San Diego and Wairika. We've always had to work things out for them. Now, even if you live within a mile, we'd still want to do a Zoom meeting.
Yeah, in light of it, and there may be another lockdown order and all this stuff. So for us to be able to continue to serve you, Zoom or phone, absolutely. Only in rare cases can we set up in-person meetings. That's only for very specific things. We're trying to avoid that to keep you and our staff safe. So again, thank you all for attending here. We actually did get to an hour. We always seem to do that, even if we mean to make it faster. Yeah. Again, Prop 19 is a big issue. You may decide that you don't need to take action, but we want you to be educated. So we hope you got something out of this. The stakes are very high. We're here for you. So contact us, our office, as soon as you can, 650-493-8070. Gilfix.com, you know how to find us. So use your meeting, your hour, if you haven't used it, or just set a meeting. Even if you use it, this is worth some time with our team. So from our family, our Gilfix and LaPole family and team, to your family, we wish you a very happy holiday season. We hope everybody's staying safe, healthy, and sane, as my mom always likes to say. So on that note,
well said, Mark. Well said.
Thank you all, and we'll talk to you guys soon.
Yeah. Take care, all.
Bye.
Hey, bye-bye now.